Till death do us part, embryos and gametes after death, divorce or separation. This event has been made possible thanks to the generous support of the Scottish Government. The hashtag for this evening's event is PETDDS. I'm Sarah Norcross, Director of PET, and I will be chairing this evening's discussion. When embarking on big life decisions such as starting a family, most people don't give much consideration to what would happen if during the pregnancy or afterwards they split up with their partner or they were to die. We were doing some research into public attitudes and understanding of fertility, genomics and embryo research. We really wanted to have a question about posthumous use in that survey. We asked the following question: if a person has passed away, should it be permissible for their stored sperm or eggs to be used for conceiving in each of the following circumstances? And we gave them 3 different scenarios. So first, if the deceased was not known to the person wishing to conceive, e.g. sperm or an egg bank, but the deceased gave explicit consent for their stored eggs or sperm to be used in this way. Okay, that's the first one. Second, if the deceased was a family member of the person wishing to conceive, and there is evidence that the deceased intended for their stored sperm or eggs to be used in this way. So we deliberately in that one didn't say explicit consent, just some sort of evidence there of an intention. And then the third one was if the deceased was the husband, wife or partner of the person wishing to conceive, and there's evidence that the deceased intended for their stored sperm or eggs to be used in this way. Again, we avoided the words explicit consent there to see what the public thought. So what did they think? Well, 60% of respondents said yes to the use of sperm or eggs donated by the deceased person for use in conception by their partner. And this was significantly higher than for the other 2 groups. And you can see on my slide, apologies, it's quite small, but you can see there the blue and the green is the sort of yes answers. And then the others are the sort of don't knows and knows, or prefer not to answer. So you can see, although there was support, there was also, quite a degree of uncertainty there with all the scenarios. So some of the questions that we think would be interesting to address this evening are, in these situations, what is the status of the material in storage? Who gets to decide what or what isn't done with it? In what circumstances is posthumous conception permitted? And what are the consequences of any recent changes to UK law in this area? The panel will each give short presentations. So we'll hear from 2 solicitors, Robert Gilmour and James Lawford Davies, and we'll also hear from Professor Abha Maheshwari, who is a consultant specialising in fertility treatment. It gives me great pleasure to introduce Robert. He is a partner at SKO Family Law Specialists. He is a solicitor who specialises in family law, and he's a family law arbitrator at the Family Law Arbitration Group, Scotland.
The legal issues then, what I've been asked to speak about is the legal issues that may arise when a couple undergoing fertility treatment or who have embryos or gametes in storage split up. So as a family lawyer, I spend most of my working life dealing with the consequences of relationship breakdown. For nearly all family lawyers, even those who have an interest in the law surrounding assisted reproduction, the reality is that the bread and butter of our work is divorce and separation. And that I don't think will ever change. That is the bread and butter, the nuts and bolts of family law. In fact, one of the nice things about having a practice in this area is that sometimes you get a break from the constant conflict and misery of relationship breakdown and actually get to help people with family creation. Of course, it is well acknowledged, though, that the stresses that infertility can put on a relationship, both emotional and financial, can be very significant. The 2016 Fertility Network survey found that 70% of respondents reported some detrimental impact of fertility problems or treatment on their relationship. When you're acting as a divorce lawyer, advising people around relationship breakdown, what you tend to be doing is looking to help people mitigate the effects of an unhappy situation that they would never have foreseen for themselves or wanted for themselves. And to that extent, I suppose there is a parallel with what we do and the role of fertility clinics, who are often helping people who never expected or wanted to be in the situation they're in. I suspect in a popularity contest with the general public, us lawyers would come a pretty poor second. And that probably the parallel stops with the one I've made. Maybe that's a question for Pet to ask. Who is held in higher regard? I don't think it would be the lawyers. Anyway, so the most obvious practical issues, certainly for clinics and medical professionals arising in relation to breakdown, is in the context of storage of embryos and gametes. And that's what I want to speak to you about mainly. There is another aspect of relationship breakdown that can have a significant impact around this area, and that's in relation to the outcomes of treatment, and in particular, the legal relationships created between parent and child. That's where I tend to be asked for advice most often. That's something that maybe, I don't think I'll have time for just now, but we may be able to come to in the question and answer session that follows. So, firstly then, what are the implications where a relationship has broken down before the point where a pregnancy has been established, where there's sperm, eggs, embryos in storage? As I'm sure most, if not all of you will know, the storage and use regulations contained in Schedule 3 to the 1990 Human Fertilisation and Embryology Act have changed this year. The limit for storage has been extended to 55 years with a provision for renewal of consent to storage every 10 years. But the fundamental principles of consent remain the same. And really, in that context, relationship status is not relevant. The law doesn't view, for these purposes, a couple as a unit. It views the two people as individuals, requiring them each to give consent to the storage of their gametes or an embryo created with their gametes. It doesn't matter really whether they're married, cohabiting, separated, in a platonic relationship. No one's right to consent or withdraw their consent can be overridden or given on their behalf by someone else. The validity of that position has been challenged. In 2007, the European Court of Human Rights had to consider the challenge that was made by Natalie Evans when her partner withdrew consent to the use of embryos created with his sperm. The court ruled in that case that it wasn't a violation either of Article 2, the right to life of the putative child, or Ms. Evans' Article 8, right to a family life. The court said it wasn't appropriate for her right to respect for the decision to become a genetic parent to be accorded greater weight than her former partner's right to respect for his decision not to have a genetically related child. And the fact that UK law provides absolute hard and fast rules around these issues, consent, which don't allow for exemptions or discretion or difficult, unusual cases, the court said was fine. It said it was quite acceptable for the UK to have a system which is clear, hard and fast rules. And in fact, the court said it thought there were some positive benefits to a system which had what the court described as bright lines. So each party is entitled to withdraw or vary their consent. And of course, that does mean that those storing clinics must take great care in this context to ensure that they do treat each individual who requires to consent to storage or use as an individual, and guard against the possibility of one party potentially seeking to mislead on the issue of consent, which, again, I'm sure most of you will know has happened in the past. I think that might have particular relevance within the context of thinking about the new storage regulations, and in particular the provision for renewal every 10 years, which is contained in paragraphs 11A and 11D of the regulations. They require the person storing the gametes or embryos to request a renewal of consent every 10 years in writing, and consent to be given from that person in writing. Now, one issue that is bound to come up is that over the course of a 10-year period, it's quite likely that some couples will have separated. And if one is writing to an address that's held, there has to be, in some cases, quite a high likelihood that only one of the two members of that couple is living at that address anymore. So there are issues to be thought about there, I think, in terms of making sure where consent is coming from. And I'm sure that is at the forefront of the minds of those who are having to address this issue of seeking renewal for consent. It's also worth bearing in mind that not all parties to a relationship will be able to withdraw consent to storage if a relationship breaks down. So a spouse or partner whose gametes weren't used in the creation of an embryo isn't a relevant person in terms of the regulation whose consent is required. So they have no consent to withdraw, although they do have a right as what's called an interested person to be notified of the withdrawal of consent by someone else, which triggers a 12-month cooling off period in which attempts can be made perhaps to find a mutually acceptable way forward. But at the end of that 12-month period, if the withdrawal of consent isn't reversed, then there is no more legal basis for storage. And while a husband's continued consent to storage of an embryo created in vitro with his sperm would be required, his consent is not required in terms of the regulations to continued storage of an embryo created in utero. So it's only the mother whose consent is required where the embryo is taken from her for storage. So the position will vary depending on the particular facts. A couple may consider themselves to be equal partners in a relationship, but not all partners will be equal in terms of their rights to consent or withdraw consent if a relationship breaks down. It will depend on the particular circumstances. So I want to divert now from the law around assisted reproduction, human fertilization, and embryology acts into the law of divorce. Now, in doing that, I should flag up that unlike fertility law, which is UK-wide and will continue to be because it's not within the competence of the Scottish Parliament, not the first time you might have heard that today, but it's not within the competence of the Scottish Parliament to legislate in that area, to look at the law of divorce. And that is an area where Scots law and the law of England and Wales are very different from each other. We are separate legal jurisdictions. And when it comes to divorce, there are some quite significant differences. Although, as I'm going to go on and say, although I can only really speak to Scots law, I don't think there are huge differences here. I'd be interested to know what any English colleagues might say about that. So in terms of divorce, there's a whole panoply of remedies and orders that a person can seek in the context of divorce proceedings. Protective orders, orders regulating care of children, orders for financial provision, division of property, and so on and so on. So are there any remedies that a person could seek in the context of a divorce action that could have relevance if they have gametes or embryos in storage? Well, I think my answer to that is not really. I've mentioned the Evans case already, and it's quite clear the view taken on the regulations there that a court is not going to intervene to overrule one party's consent or withdrawal of consent. You're not going to have a court interceding, I don't think, in a divorce action to force one party to do something they don't otherwise want to do. One way to look at this, I suppose, is to think that in broad terms, in an action of divorce, generally a court's looking at making orders in two areas. One is in relation to children. And in this context, the law wouldn't recognise there to be a child. And the other is in relation to property. So in that context, are we looking here at a situation where there is property? I think this is a really interesting issue. Is sperm in storage or eggs in storage or an embryo property? Can it be owned by somebody? So the answer to that question appears to be no, or at least it isn't property in the sense that would allow ownership. Now, I must admit the law around this area really makes my head hurt. We get into some fairly deep philosophical stuff here, but there are cases about this if you're interested. The question was considered by the English courts in the Evans case. There's another English case, Yearworth, and North Bristol NHS Trust, which looks at this issue. But the case I put in a word for here, if you're interested in reading about this, is a Scottish case. I have to stick up for Scottish jurisprudence. The case I'd suggest you have a look at is called Holditch, Holdich, Holditch against Lothian Health Board, which is a case from 2013. A really fascinating discussion in that about the question of whether one can own part of their body and so on. And I can't, I have to say, claim to understand it all. At one point in that case, there's a discussion of the parallels to be drawn between Shetlanders taking ownership of small whales by driving them into a bay to slaughter them, and a man depositing his ejaculate in a receptacle and handing it over for storage. But the bottom line after 8 days of argument in that case is that it seemed that Mr. Holditch's sperm in that case couldn't be considered property that was the subject of an ownership dispute. So there doesn't really seem to be much of a basis on which I think the courts in a divorce context are likely to be able to intervene or intercede in any disputes between parties in this context. There are some issues around the edge, perhaps, where divorce could have some relevance, largely in relation to money. So I think, for example, if there are charges being paid to a clinic for storage, then I think it would be quite competent in divorce proceedings for one party to seek an order requiring the other party to pay those charges. So one could posit hypothetically a position where a husband on divorce is asked to pay the ongoing cost of his wife's egg storage, even if he's not going to be involved in the treatment that uses them. But I think those types of issues are really, as I say, issues around the edge. They're kind of incidental issues rather than fundamental issues. So can I leave you maybe, coming to the end of my time, with a question? I'd be really interested to know what other people's views are on this. One particular scenario that intrigues me in this context is, let's imagine a scenario where a female couple have treatment together. They're advised against using their own eggs, so they use donor eggs and donor sperm to create embryos, and then they separate and they both are with new partners. They both want to retain the embryos for use with their new partner. Who gets to use the embryos? I don't think, and I've asked a few colleagues about this, I don't think there's a legal answer or potentially even a legal avenue for resolving that question. It's not resolved by withdrawal of consent, because in that context, neither have a consent to withdraw, at least as I understand the regulations. And as I've outlined, this isn't a property dispute. So what is the solution in that situation? How do we resolve the problem for that couple? I mean, I'm sure this must have come up, and I'd love to know in practice what the solution is, because, as I say, I don't think the law does have even a method, a set of rules to bring to resolving that issue.
Our next speaker this evening is Professor Abha Maheshwari. She is lead clinician at Fertility Scotland, and she is clinical director and lead consultant for reproductive medicine and surgery at the Aberdeen Fertility Centre.
Thank you very much, Sarah, for asking me to speak on this really important topic, which is the posthumous use and the use of new consents. As you can see in the purple was the previous consent forms, that is the woman treatment consent form that everybody undergoing IVF and ICSI used to fill in. And it asks you whether you consent for your eggs being used for training purposes and or your embryos created using your eggs used for training purposes. If you die or if you become mentally incapacitated. So they ask you only for training purposes, but as you can see at the bottom, there was a caveat that if you want your eggs or embryos to be used in someone else's treatment, if you die or become mentally incapacitated, please speak to clinic regarding more information. Depending upon your circumstances, you will need to fill more forms and you have to undergo other things like screening. So in the new forms, there are now 4 questions, which are slightly different because we are not asking just for the training. We are asking whether in the event of your death, do you consent for your eggs being used to create embryos outside the body and those embryos being used and stored for your partner's treatment? Same is for embryos, same as when you get mentally incapacitated. So it also says that if treatment would involve a surrogate, then additional consent form and screening must be completed before you die to allow treatment to take place. So what it means is just by saying yes here does not allow those embryos or eggs to be used for treatment after you die or after you become mentally incapacitated unless these steps are being taken. This was always there, as you can see from the purple side of the form, but not as explicit as it is in the new forms. And the reason it is so explicit in the new forms is because of a court case which recently happened at the same time as the new consent form with the new laws were changing. So this is not a new law. This is just more explicit on the consent forms. I think we have to differentiate with that. We're making clearer to patients that they can do those consents. However, what does that mean if you tick yes? If you tick yes to any of these 4 questions, additional screening will be required. Ideally, this should be done at the time of creation of embryos, because that's the best time to do all the screenings, and as per regulations of um, how to use gametes in the cases of surrogacy. You have to fill in detailed questionnaire which asks for infection and genetic diseases, because both partners are here treated as a donor. The infection screen timescales are very, very tight. They are defined by the donation regulations as per the HFEA guidance. There is a genetic screen required based on the history, but karyotype and cystic fibrosis get done for all. Counseling and extra consent forms, as are already mentioned in the form. So what does that mean? The screening that is required, here's the list. As you can see, only hepatitis B, C, and HIV is routinely done, and only done once within the 90 days of your egg collection. Rest of them are extra, and it's not just before the creation of embryos, it's after 3 months after that as well. So there is a quite lot of extra screening, extra visits, and in top of that, there is genetic test. So what we did is we did the optionals appraisal to look at the various options and see what can we do without delaying your treatment, because the important thing is you come to us to have a baby, and we want you to have a baby without any delay. So the option 1 was that we screen everyone with all these screening tests and extra questionnaires and everything, whosoever says yes to the posthumous use prior to creation of embryos. So this is only applicable to the woman treatment where you are ticking yes. It is always there for men who can allow their female partner to use the embryos created using their sperm or use their sperm. And there's again nothing changed in the new forms about that apart from duration of storage. So if we go down the option 1 route that we screen everyone, it's an ideal form of screening. That's the positive. And embryos can be used for donation in future if you've got spare embryos, because currently if you've got spare embryos and if you want to donate it for somebody else, then you have to undergo all this screening retrospectively. The disadvantage is it's a huge cost to NHS if NHS is paying, and if you are paying, it's a huge cost. A rough calculation, again, back of envelope, is 1,500, 2,000 per couple. So even if there are 20 people in an average size clinic who take yes in a month, you're talking about 30K extra per month, which is a huge amount in current economic climate, in any economic climate for that matter. There is time involved. There is time for all staff, including counselor. And what does that do is it increases the waiting time to see other patients or you to have second or third cycles, because staff are obviously busy sorting out these screening tests right time. So it's be difficult to make the treatment time guarantees. There will be extra burden on lab who are already stretched beyond the limits, and there will be delay in treatment because we have to have those screening tests and have their results, and if anything is positive, we have to deal with it. So that's not really what is called as realistic medicine. So we looked at the option 2, that we screen for infection but not screen for genetics, which definitely reduces the cost, but still there is a cost, still there is time involved and implications for waiting time for your own as well as for other people on the waiting list, their treatment. But the disadvantage of this approach is if a woman becomes mentally incapacitated or dies unpredictably before you can do the genetic screening, then we can't use them for posthumous use as for surrogate, because that we won't have completed the screening at that time. And these things do happen sometimes unpredictably, but they are rare, very, very rare. And again, the staff time to chase up who has got what done and what not done, and it does take a lot of time and effort, and again, implications for treatments for everybody else. So the third option was we screen only those people who've got embryos to store. Not everybody has spare embryos to store, so that removes automatically 50% almost. which has the advantage that we are not delaying your own treatment. But embryos can be used for donation in future if we have screened them, if you've got embryos there. The disadvantage is, again, as I mentioned in the previous option, that if something happens unpredictably, then we cannot use the embryos for posthumous use. And again, we have to chase up who has got embryos in storage, then call them back to have all those tests done, and then repeat those tests. Also, because the screening hasn't been done prior to creation of embryo, we will need to do risk assessment at the time of use. And if you're using it for yourself, the bar is slightly lower, whereas if you're using it in a case of surrogacy, the regulations are much tighter. So it's not, although it's similar to embryo donation, it's not entirely similar, because in embryo donation, you're using it for yourself. So again, it's not realistic medicine that you screen everybody who's got embryos in storage because of the cost, time, and other implications. The other option is that we only screen when you've completed your own treatment, you've got spare embryos, and you're thinking about future, or you get diagnosed with an illness. Now, that reduces the number of people who needs to be screened, and that is realistic medicine for those who need to use it or likely to use it in this respect of posthumous use. We will still need to do risk assessment at the time of use because we are doing the screening retrospectively. But at the same time, onus is on patients to, if they get diagnosed with illness, they will remember to contact us, because there is a lot happening when you get diagnosed with any illness. One option is that we put an alert in electronic medical records that if you get diagnosed with anything, then you get alerted to come back to the fertility center. However, currently we can't do it because of the confidentiality regulation with HFEA. And we also know that all those who have stored sperm, not everybody remembers that they have actually stored sperm as a part of fertility preservation. So I think more need to be done about this to raise awareness of it. We took in consideration all these options and thought that what is the best use of resources in a publicly funded healthcare system, and a pragmatic approach so that we do not delay your treatment and not ask you to pay unnecessary extra for tests, which you'll probably never be needing to use it. So looking at number who will be needing to screen for that one very, very, very rare occasion, and taking in consideration individual versus societal gain, we've agreed that within Scotland that we'll do similar screening as for embryo donation, means we'll screen retrospectively only when your treatment is completed or you come back to us if there is any illness. But for that, we are doing a lot of communication. We have sent letters to patient. We have got some feedback on those letters, and the version 2 is being modified, which will be sent out. Again, it requires a lot of communication with the clinics, with the patients that come to us if you've got any questions about that. But we didn't feel that it was right to screen everybody from the beginning. But we are still learning a lot, and there are still maybe a lot of unknowns. So we will be taking all the feedback and modifying the practice as we go along.
So we have our final speaker now this evening. He's joining us not from his home in Yorkshire as he normally does, but from Athens. So we have James of Athens, which sounds like a somewhat Shakespearean play. So we have James Lawford Davies.
Perhaps contrary to many expectations, the Warnock report was actually quite against the notion of posthumous use. Anyone that's looked at the parliamentary debates in the 80s might remember that there was a lot of concern and consternation in the House of Lords in particular about the damage that might be done to peerages and inheritance rights and large estates in Scotland And that seemed to drive the concern about posthumous use in particular. But the Warnock Commission didn't think it was a very good idea, and thought that children might suffer as a result of being born after the death of one of the parents. But that extended for a number of years after the introduction of the legislation. And it was interesting to compare the data from Sarah's survey, PET survey, with a paper that was published by Liz Corrigan and the rest of a team in Bristol back in the 90s, which showed that actually a significant minority of clinics in the UK, as late as 1996, would not allow patients to have posthumous treatment. As many as 40 clinics you can see on this table wouldn't allow the posthumous use of embryos. But as far as the law is concerned, there is no prohibition, although there are a number of relevant qualifications and considerations that have to be taken into account. The Act is relatively silent in relation to posthumous use, simply saying that consent must specify what's to happen in the event of death. But the HFEA's Code of Practice puts a lot of flesh on those bones, setting out in considerable detail what information the HFEA expects to be provided to patients before they give consent, specifically in relation to the prospect, however unlikely it may seem, of unexpected premature death. I won't go through these requirements in detail because I'm sure you're familiar with the code, but it's pretty easy to find the specific provisions that relate to what should be said to patients before they consent about posthumous use and the potential complications that might arise, both in relation to treatment and, as Robert has talked about already, some of the complications that can arise as a result of long-term storage. So I want to spend the remaining time looking at the key cases, the first of which many of you will have heard me talk about before, which is one of the really key cases in the development of the law in this area. Ironically, though, nothing to do with IVF at the time of that the question arose. So Diane and Stephen Blood were happily married, but they were not IVF patients. So here we're not dealing with a question about mistakes in consent forms or missing forms or anything. There was no written consent whatsoever in place. He fell into a coma as a result of a rare form of meningitis. And Diane asked Ian Cook, who ran the unit at Sheffield, to extract sperm from his testes before he died, which he did. And then the question arose whether it could be used in the UK, and if not, whether it could be exported to another country for use there. And she was refused permission both to use or store the sperm in the UK and for export. And she took the HFEA to court. And it ended up in the Court of Appeal. And she was, as you can guess from the previous photograph, ultimately successful in being allowed to take the sperm to Belgium for treatment, where she had 2 boys. But the court drew a bright line in relation to the statutory requirements for consent and made it absolutely clear that although in this case, in a novel case where the question hadn't arisen before, there was no criticism to be made of the clinic, going forwards, it would be a criminal offence to use or store sperm without written consent, as is required under the 1990 Act. I want to briefly mention 2 cases which don't qualify that and certainly don't change the law, but I think they're important to take into account in the very specific situation where you have a patient who is still technically alive, but likely or certain to die. There have been circumstances where the courts have been willing to look at the best interests of patients who are still alive through the Court of Protection, which looks after those who are unable to make decisions on their own behalf. And in 2018, a case arose in relation to a man who'd suffered a catastrophic brain injury as a result of a motorbike accident. And his wife wanted to have sperm obtained prior to his, what was then inevitable death. And the court looked at a wide range of factors relating to his life and their relationship, in particular the fact that they'd been married for a number of years, that they were trying IVF, although there was no sperm available, but they had an appointment with a clinic for some time quite shortly after his accident. And although he hadn't provided explicit consent to posthumous use, he had discussed it with his wife, and the court accepted that that was true. So in those circumstances where he was still alive, the court was able to make a decision that it was in his best interests, despite his imminent death, for sperm to be obtained for use after his death. You can contrast that with a very recent case, just from a few weeks ago, where the court declined such an order in circumstances where there was very limited information and evidence as to what the man in that case wanted, what his wishes or views were as to what might happen in the event of his death. There was no evidence from his girlfriend, and the court drew a distinction between circumstances where sperm is taken from a patient who is unconscious and dying to somebody talking about whether or not they might like to have a family at some point in the future. So there are these circumstances where the courts will look at the interests of somebody in a similar situation to Stephen Blood, but they're very case specific. These cases don't change the 1990 Act, as I say, and any such case would have to go before a judge to make a declaration. Otherwise, the position would still remain the case that it would be unlawful to store or to use sperm without consent. Going back to my chronology then, the next case that came up that I think is relevant to posthumous treatment and the development of the law was a very sad case, again from Bristol Centre for Reproductive Medicine, where a couple had treatment or had started treatment and completed their consent at home, and both had ticked that they did wish to consent to posthumous use. The centre had an ethical policy of not allowing the posthumous use of embryos. And so they said, well, you can either change your consent or we can refer you to a different clinic. So they both crossed out the ticks and ticked no to posthumous use. And shortly after, Mr. Yu suffered a catastrophic and fatal asthma attack and died. His wife, his widow, then sought to argue that he hadn't intended to change this instruction and that he'd only done so at the request of the nurse at the clinic, and therefore it wasn't a genuine amendment or variation of his consent. And the Court of Appeal rejected this argument, saying that clinics must rely on a form that is presented to them unless there is good reason to doubt the representation. So perhaps a forgery forgery certainly would undermine the validity of the consent, but unless you could satisfy a court that that a patient had been put under duress to give a specific instruction, the court couldn't look behind that, however awful that the consequences of that would be for the woman affected. The next few cases I want to look at are where there is a lack of specific consent. And this case relates to Elizabeth Warren, who's pictured there next to my tatty briefcase. And she's smiling because she's just been granted a declaration by the High Court allowing her to keep her late husband's sperm in storage and to use it for up to 55 years. It's a complicated case. He had sperm stored prior to chemotherapy at a clinic which had a policy of asking patients to store for 2 or 3 year periods according to the availability of NHS funding. So he had given a series of sequential consents to store and also consented to posthumous use and named Beth, who then during that period also became his wife. The last of those periods was coming to an end, so the clinic said, well, do you want to write to him to say, do you want to extend your storage again? He ticked a box in a letter to say, yes, I wish to do so. So they then applied for more NHS funding and sent him the HFEA forms to complete. But in between, he died. So he was unable to complete further consent to storage forms. And the clinic contacted the HFEA. He said that in the absence of further renewed consent, the sperm had to be used before the end of the last consented storage period, and after which time they couldn't remain in storage. So the case again went to court, and the judge again looked at a wide range of information, a sort of mosaic of information, which she pieced together to satisfy her that had he had the opportunity, Beth's husband would have consented to the maximum possible storage period and would have wished her to be able to use it in the event of his death. Again, it requires the court to make that decision. A clinic can't, although it may be aware of the same information, the clinics can't make that decision on behalf of patients in relation to storage. The next case in the series is another case about the variation of consent. this is Samantha Jeffries and her husband Clive. They had treatment at a clinic which also had a policy of asking patients to limit their consented storage periods to match the availability of NHS funding. Clive and Samantha had completed consent forms and both consented to the maximum 10-year storage period. And at some point, and it wasn't clear, and Samantha didn't remember exactly what had happened, at some point, Clive's consent form had been amended and the 10 had been crossed out and 2 years had been written in. All of the other amendments on his form, he'd been in the Royal Army Medical Corps, all of his other amendments had been initialed, but the amendment to the date period had not. And a number of months after those forms had been completed, Clive had a massive brain hemorrhage and died very suddenly and unexpectedly. The case went to court, and this all turned on the amendment of the consent. So the James Munby, the then president of the Family Division, looked at the Act, which says that consent must be signed and in writing. And he said, well, the original 10-year period was signed, and therefore that was valid. The amendment wasn't, and therefore it was ineffective to vary the storage period. So the 10-year period remained, and Samantha happily was able to keep and use the embryos for up to 10 years. And I pause briefly only to say that I think that's a really important reminder to clinics to check if you do have amended consent forms, that they are initialed or signed, or that new forms are completed and signed. Because whilst this is a very happy outcome for Samantha, you can, I'm sure, imagine circumstances where the consequences of an amendment not being effective could have unwelcome consequences. Bringing us more up to date now, a recent Scottish case from 2020 related to a young man who had sperm stored prior to treatment. And although they were pursuing fertility treatment at Aberdeen, they hadn't actually started their treatment, and he died before their appointment. In his will, he included a clause which specifically addressed the stored sperm that he wanted to be available for use by his wife. But no HFEA consent form had been completed in relation to the continued storage and use. For reasons which I won't go into, there was an MGI form, but not an MT form to consent to IVF. And the Inner House looked at this in great detail and was satisfied that the will constituted sufficient consent to meet the requirements of the 1990 Act. So again, they looked at all of the information from the family and all of those involved to come to that conclusion. So again, a positive outcome, but only after taking into account all of that wide variety of information that was available, and crucially, the fact that he had signed had amended and signed a will to specifically address the posthumous use of his sperm. And then most recently, the case of Ted Jennings, pictured here with his wife Fern. Ted and Fern had treatment at CRGH, and Fern very tragically died while carrying twins as a result of that treatment. They have an embryo which remains in storage, but Fern had not completed the consents that Abha's talk showed you in detail. They completed all of the other relevant consents and consented to posthumous use, but there was no consent to posthumous surrogacy and no screening. So Ted made an application for permission to use it, and the High Court held that whilst the forms that Fern had completed gave some prompts to request to proactively ask clinics for additional forms to consent to posthumous surrogacy, they weren't clear. And she was satisfied that, again, looking at all of the information available, it was possible for the court to infer that she would have consented to Ted using the embryo in the event of her death, and with a surrogate. All of these cases have involved incredibly brave, strong people who've been faced with tragedy and often unexpected, hugely premature suffering and death. If you delve into the dark sort of dungeon of the Daily Mail comment section, when people have decided to comment on these cases, they usually suggest that they're selfish or they're not taking into account the interests of their children, the prospective children, or what have you. And I can say categorically that not one of the cases that I've talked about has involved anything other than people who are genuinely trying to achieve what they believe and know to be the wishes of their deceased partners, and have been utterly selfless in their pursuit of what they believe to be right. But they are difficult and complex cases. It's not enough to know that this is what somebody intended. There needs to be consent, unless you can persuade a court that the information that's available is sufficient to constitute or to infer consent. It does place a great deal of emphasis on the importance of discussing difficult topics with patients at difficult times, and to make sure they understand that some of these complex situations may follow. And it might be useful to refer to some of these cases as a way of, as a hook to raise what might seem rather inappropriate questions and discussions at an important time in their treatment. It also highlights the importance of keeping in contact with clinics. But I emphasize again, although I've talked primarily about positive outcomes for patients, in the absence of a court order, only the position remains that there must be consent in place. And it's only the court that can give effect to these wishes. It's not down to clinics to make that decision.
What do the panel think about the gametes of someone who has died being used in donor conception?
It is a very difficult ethical dilemma, but we do use, with the current consent, donor, unless they consent for the fact that even if they die posthumously, we can use their gametes. But it will create issues in future, as you have highlighted, that if people are not able to contact their genetic link. However, this is all covered as part of the counseling process when we are using, obviously, any donor gametes. This is all covered in the part of counseling and part of information given. And equally, we do not know unless somebody tells us, or is there any way of knowing that this donor has passed away. Once donor has given the consent, unless we know that donor has passed away and has given consented posthumous use, we will continue to use it, provided obviously there is a consent for that duration of use. So I'll be kind of keen to say what James and Robert have to say for it.
James, we'll go to you then first, and then see what Robert would like to add to that one.
Yeah, well, I agree with everything Abha said. There's no legal obstacle to it, providing it meets any conditions or time limits on the storage and the consents provided by the donor. As you said, Sarah, it's more of an ethical question than a legal question, but there's no bar to it in law.
Robert, is there anything that you want to add, or?
Not really. I agree. I think it is an ethical issue rather than a legal one. I personally don't think the issue of a child being able to make contact has a great deal of bearing on it, because that's going to be the case in many other cases anyway by the time a child is seeking to do that. So yeah, I mean, ultimately I think it is an ethical question.
And I do wonder whether some patients might think, if they were aware that a deceased donor might be preferable in an identity release world. I'm not saying that all parents, all potential parents would think that, but that is certainly something that some people may consider would be less of a potential threat to their family in the future if that were the case. Anyway, interesting, probably a subject for another night to think about those. So I'll move on now to the next question, which is probably really for James, and perhaps for Abha. I'm sure Abha will want to come on this as well, though. Do you think the additions to the HFEA consent forms post-Jennings is a bit overkill in relation to something that's not likely to happen very often? Could it have been dealt with in a different way so as not to overcome overcrowd already complicated and burdensome consent forms? If so, how do the panelists think that we will see more Jennings-style cases? So we'll go to you, James. You were involved in this Jennings case, so I'm sure some people are probably silently blaming you.
The HFE are kind of damned if they do and damned if they don't. The court was critical of the layout of the forms, so they had to do something about that. I suspect. I shouldn't speak on their behalf, but I think if you can somehow reduce or minimize the risk of confusion or lack of clarity in patients' minds, then that's probably a better thing. But I think the emphasis, as I said at the end of my slides, the onus is really on clinics to talk through these issues with patients, because you can still, however many tiny boxes you ask patients to tick, you can see them whizzing through and ticking yes very quickly without really thinking about the consequences. But I defer to Abha in terms of whether it's overkill.
I would agree, as I said in the talk, that nothing has changed. We were meant to speak about it even before. It has made it more explicit, but this is in the interest of transparency and giving patient choice. Patients should be given the choice. I think what is important is giving them the information. The implications of ticking yes here is just by ticking yes here is not enough. There is a more to be done, but what point in the journey that more to be done, because they have come for their own treatment, let's get on with their treatment. And then, and as it is clearly mentioned in the form, that de-screening and further surrogacy forms have to be done before you die. Obviously, it's very unpredictable sometimes, but the likelihood of that happening is very, very, very small. So let's concentrate on the treatment first, and then obviously talk about, it's a pragmatic approach. You cannot get 100% things right for 100% of people, 100% of the time. And what is in the best interest of everybody, because you don't want to delay anybody's treatment either. But I still re-emphasize that nothing has changed for what was the consent before. It has made it more explicit. If it wasn't in this case, Jennings case, it would have come in another case. So the consents probably would have to be made more explicit. And I agree with James. If HFEA didn't do it, they're doomed. If they did it, they're doomed. So it is fair to be more honest and transparent. And just information given to the patient is what is more important.
Yes, and I wonder if anyone, I don't know whether anyone working in a clinic has done some sort of cost-benefit analysis of not doing all the testing and the chance, the probability of ending up in a scenario where you've not done the right thing, and what that sort of cost-benefit analysis would be of the quite expensive legal fees that would be involved in that court case. Anyway, that's something that popped into my head when I was thinking about that question. So we've got a question now from another anonymous attendee, and this is for Robert. So what happens to a stored embryo after divorce or separation if donor sperm has been used? Does it become the woman's as it's her original gamete? Would it make a difference if a sibling had already been born where both ex-partners are the legal parents?
Okay, well, I'm really interested to hear what both James and Abha have to say about this as well, I have to say. I think my understanding of the regulations is that it would only be the woman who required to give her consent to storage and use, and she could vary the basis of that consent. I think using the word "it becomes hers" is where it becomes a bit tricky, because, as I say, I don't think you can conceptually think of this in terms of ownership. But certainly my understanding of the regulations would be that she would be the one who was in control by virtue of her consent to what happened. That is certainly my understanding of the regulations. I think that practice would be interesting to know in practice how that situation is dealt with.
So, James, do you want to come in first, and then we'll go to Abha?
I think the use of donor sperm in that situation is a little bit of a red herring. The same consent, it's the rules around consent that matter, not the fact that, because you could have an embryo created with donor eggs and donor sperm. So the question becomes, what should be done? Now I've had a series of queries from clinics relating to whether or not an embryo in that situation can retrospectively be donated. So the husband, let's say it was donor egg or not, but whether the husband can just agree to donate the embryo as a donor rather than take on legal responsibility. And the Act is extremely complex around that. And what matters is the status of the male partner at the time of the creation of the embryo, not what happens subsequently. So it's a murky area, and as Robert says, it's not that the regulations aren't entirely clear. But I'm not sure that the use of donor sperm in that situation is what really matters. It's the usual rules relating to consent.
Abha, is this something you've come across in your clinical practice?
We do, but I will be on the phone to James and Robert to seek advice for a specific case, because it could be very legally complex. It could be in the same-sex couple as well, using donor sperm, not just a kind of a cis male and cis female. So it depends on what actually the scenario is, what consent they have given, and what the status is. So you can't kind of generalize it. It is complex. And as I say, I'll be looking at James and Robert to help me out there if there is a case like that.
With the same-sex couple, the embryos were created with one of the patient's eggs and donor sperm. If they separate and later on the partner whose eggs were not used claims she paid for the sperm and does not allow the other patient using the embryo, what are her legal rights? What's the legality of this?
I think payment is a red herring in that situation. That's not going to be what determines what should happen. It's going to come down to, as James said in relation to the last one, the consents that are in place. I think payment is a red herring. I don't know if James agrees with that.
This happens a lot, and what I usually suggest is that clinics encourage the couple to try to resolve their differences rather than getting dragged into it, because these are personal disputes between couples. It's not for the clinic to be trying to mediate in a situation like this.
Yeah.
But obviously they can be dragged into the consequences if it starts to become litigious.
I mean, it may be worth saying here, Sarah, that there is perhaps a parallel here with some of this to what we see in surrogacy arrangements. When we have in the UK, surrogacy agreements are not legally enforceable contracts. You can't litigate on the back of and seek to enforce a right in those, but we still nonetheless encourage people to enter into surrogacy arrangements in many situations, because the simple act of going through and thinking about what you would want to happen in lots of situations encourages people to think through what their attitude might be and record that. You remove the risk of mismatched expectations. You encourage people to actually think about what they'd want to happen. And the act of doing that, you hope, produces a situation where if something does go awry, there's less likely to be dispute. And I think there is a parallel here. These are all things that there is no reason why a couple should not be sitting down and looking to flesh out some kind of, not a legally binding agreement, but nonetheless an agreement, a statement of their expectations about what they would want to happen around these things.
What do the speakers think about the change to the law that now limits storage to 10 years after the date of death? So with the changes to all the storage periods, 10 years, a 10-year limit was put on the posthumous use. So I'm going to go to James first on that one, because we have something, I think that is something that James and I have actually discussed.
Yeah, I think it's going to be tricky. You can envisage circumstances where 10 years might not be a very long time. If an embryo has been created or if sperm has been in storage for a few years already, somebody then has to deal with a horrible situation and sort themselves out before then starting to think about treatment. So I think it may well lead to some tricky situations where that becomes a very narrow window of opportunity. I'm not sure what the best way of dealing with that is, but again, I think it highlights the importance of raising these complex situations with patients at the time of the consent.
Do any of the other panelists want to come in on that one? Abha?
Yeah, no, I mean, it depends on how you look at it. Obviously, 10 years may not be enough, but the two cases I have dealt with where the consent was only left for 2 years and the husband have just passed away. And because it is only 2 years left, and we are then forcing this patient to say, well, we can't use it after 2 years because there is nobody to extend the consent. So on that note, 10 years is a positive so that you have time to think about it and you're not being forced to use it in a short period of time, whatever is left. But equally, for some people, as James has said, that may not be right. And it depends on individual circumstances. And again, the consent and information given before the consent is very, very important. So it is a lot of time taken to do the right consents.
Thanks, Abha. I'm going to move on now to a question for James and Robert from Scott Nelson. So Scott would like your opinion on the NHS Scotland pragmatic view which Abha outlined in her presentation, and the risks and implications of this policy in the situation of an unexpected event and it's challenged legally. The ship will have sailed and screening won't be possible, so posthumous isn't feasible. So what do you think about their policy? Let's I'll go to James first and then to Robert.
Well, it's a difficult area, and I think it's interesting when you look at the Jennings judgment. The court didn't address and wasn't concerned with the fact that Fern hadn't been screened for everything that was required. I don't know whether that was an intentional oversight and a sort of fudge, if you like, to ensure the outcome that that Ted received, or whether it was that they felt that the absence of a chlamydia screening for a woman who'd been happily married for a number of years and had fertility treatment was a nonsense. I don't know. But I do think that the standards that are applied in relation to testing and screening, they all stem from the European Tissues and Cells Directive, which was drafted very much with the human application of other tissues and cells in donation and transplant and so on, not with reproductive medicine, although obviously they were adjusted for reproductive medicine, but still it stems from a very different area of clinical use, and I think fits uneasily with some of the scenarios that we've looked at this evening. So if there is a pragmatic approach, then I'd be all for it. But there is the possibility that somebody would be very unhappy if they weren't able to proceed because of the lack of screening purely based on cost. What I don't know is whether there are other alternatives. I don't know, for example, whether if a blood sample was held for every patient, whether that would provide an opportunity to screen further down the line, or whether that would be inadequate. But that, I suppose, in itself would carry a cost to store blood samples for patients, and it would create its own bureaucracy and biorepository issues. So it seems very clunky to me at the moment that this is the only way that we can proceed. From
the Act, it's not clear that they would, they talk about consent, not for consent plus a battery of tests, and I wonder whether, if there is, hopefully there will be review and reform of the Act, that this could be something that is perhaps dealt with under that.
Yeah, certainly. And there's also going to be a review of the European Tissues and Cells Directive. So depending on how the UK interprets that, it may lead to a number of changes on a number of different levels. But I think it's some of these cases have highlighted the potential complications caused by the requirements. And so when it does come up for review, it would be good to have scientific and clinical input into whether there is even any clinical necessity for some of these screening requirements, because as I understand it, there are big questions about whether there is in fact any risk to a surrogate in carrying an embryo, even in the event that somebody had tested positive for chlamydia. So I don't know what the purpose is of some of the tests when applied to the surrogacy scenario.
Isn't one of the bigger problems, other than a lack of consent, in cases like Re-X mentioned by James, the fact that it was the man's parents seeking posthumous use? Do panelists think use by the deceased's parents is ever appropriate? And I think that was something a little bit that was picked up in our survey, that people have different attitudes to different people making use of the gametes.
It's very fact and case specific, and I can imagine all judges in the Court of Protection being incredibly thorough in the way that they review the evidence that's available to them as to what the patient wanted or would have wanted, and that doesn't detract from the significance and the relevance of the wishes and the evidence provided by family, whether it's parents or other relatives. And certainly in the cases that I talked about, the courts did listen to what the parents of Warren Brewer, for example, what his parents said he would have wanted, because they knew him as his parents. But it is a different qualitative form of evidence, and I think there would need to be more than just the parents saying that that's what they wanted. I would quickly mention a case which I didn't include this evening, which is the M&M case, where the parents of a woman who had stored her eggs prior to her death were permitted by the Court of Appeal to take them to the US, so that the mother could be treated with those eggs at a US clinic, following a legal challenge. Now that's a complicated case, but in that case, the court was evidently satisfied to a certain extent by the evidence that was provided by the woman's parents. Although there's a lot more to that case, and probably not one to summarise too quickly.
Abha and then Robert, what do you think about grandparents, I suppose, or potential grandparents using posthumous embryos or gametes?
So I think every case has to be dealt with. I mean, these are very, very rare cases, and every case has to be dealt with individually, looking at the circumstances, what the concerns are, what the implications are, what the ethics scenario is, what the legally what is allowed and possible is. So I don't think we can generalize it, but equally at the same time, you could have, because we are now storing for 55 years, that daughter may be wanting to use mother's egg at a later stage. So there could be, all sorts of permutation combination. So I would, you look at individual case and look at all possibilities, what is feasible and possible and ethically right, and involve the right people who need to be involved.
And Robert, I suppose you come across this in a sort of, well, not the same thing, but similar-ish in your divorce work, perhaps, or in custody work, where perhaps grandparents are seeking access if there's been a really bitter dispute.
Yes, grandparents in that context, certainly in Scotland, are not given any special status. Anybody can apply for parental rights and responsibilities in relation to a child if they can show an interest in why it would be in the welfare of the child for them to have those. But grandparents don't have a special or particular precedence or right in that regard. So I mean, this particular question isn't one that I've really had to give any thought to in my practice, but insofar as the question is, could there ever be circumstances in which it would be appropriate? I think it's pretty clear from what James and Abha are saying is that there certainly can be, but those circumstances would need to be looked at very carefully.
Yes, these are all, I think, when things are rare, and thankfully these are, it does add that level of complexity, because you don't have that, no one has that sort of at clinics or on the legal side, that whole body of this is what always happens in this scenario. And also, when you involve people in disputes, it gets so complicated so quickly, and each case ends up having very specific facts. So the next question is from someone who's anonymous. For male patients that died before the July change, that's to consents, who are coming to the end of their consented storage period and consented to posthumous use, but less than 10 years post-death, is there any room for allowing these samples to be used? That sounds like one for you, James. That's a bit of a noodle baker, as we'd say in the pet office.
Well, yes, but again, it sort of depends on the circumstances and what situation they were in. So for male patients that died before the change, that there isn't scope for it to be extended again, because they can't consent because they're dead.
They're dead. Yep.
So the only the variation on this scenario, which the HFEA addressed, was for patients who were relying on extended storage under the old rules, and they encouraged clinics to contact them before the change in the law so that they could renew their maximum, their MPS to get the maximum period out of it. But that's not what this question is asking. So it would depend on the details.
Okay. The next question I'm going to take is for Robert. When a couple split up and have created embryos together, do you think that the year cooling off period, they have to think about this? This is if they've fallen out, is a good thing if they can't agree on what should happen to them. What would you recommend that couples do in this scenario? Is there some form of arbitration or conflict resolution that they could use?
Well, I think some form of cooling off period probably is a good idea. I think the opportunity to reflect in these kind of situations is always useful. I mean, that's kind of baked into our divorce law, certainly, if you think about it, in terms of the fact that absent, behaviour, you're looking at waiting a period after you've separated before you can ask a court to formalise your divorce. That's not directly analogous, but that's another situation where the law has decided it's sensible that before people take irrevocable decisions, that there's an opportunity for them to reflect. So I do think it's appropriate. In terms of what a couple should do in that situation, well, there are various dispute resolution methods open. You're not going to be able to put this before a court to rule on. And arbitration is also a form of dispute resolution, which effectively involves putting the decision into the hands of someone else and having a third-party decision maker, which, again, in this context, I don't think is the answer. I think I'd probably be directing people towards something like mediation, some kind of more voluntary and consensual dispute resolution method. I mean, I would have thought a situation like that is very apt for mediation. And that's probably where I'd be directing people in that situation.
Abha, have you had patients in this scenario, and have you felt that was in your skill set really to advise them what to do to try and come to a amicable decision, or is it something that you think is outside the role of the clinic really?
I think whenever they separate and whenever there is a dispute about embryos, we obviously sit down with them, speak to them, arrange counseling sessions with them, because obviously counseling is very important. But at the same time, I mean, we do give a year of cooling off period, which is what the law is currently. So again, it's a very individual circumstances, and I agree with Robert that mediation, or if it's not, usually it's not possible, because obviously that's why they're separating out. So we give a year of cooling off period unless they both withdraw the consent.
Robert, would the idea of mediation then come in for that exam question you set at the end of your presentation about what to do with that same-sex couple who'd used donor eggs and sperm and both of them wanted to use it?
I think that would be potentially a good practical way forward. I mean, I posed this question to a number of people over the last couple of days just to get some sense of what people thought. And I think the most common response I got was, well, how many embryos are there? Because the place most people went to first is, well, you know, are there enough that they can both retain? That seemed to be most people's initial response to the dilemma. But yeah, I think mediation might well be apt in that situation. But of course, the point of mediation is it can't produce an outcome other than by consensus. So it doesn't guarantee an answer.
No, absolutely. James, did you want to comment on the question that Robert posed at the end of his presentation?
I need to reiterate what I said before, that I always encourage clinics to try to encourage the couple to resolve it rather than being dragged into personal disputes. On the cooling off period, I used to be concerned that was prolonging agony, and I couldn't see much benefit until I spoke to a growing number of clinics who found that in fact during that period couples reconciled and then continued with treatment. So I'm a convert to cooling off.
So yes, and I can remember us having those conversations actually when you were not a fan of the cooling off period. So that's very interesting. And good to know that it actually works, or works in some, obviously some cases. So I've got time for a few more questions. So one for you, James. If embryos are about to expire and the patient says she's going to contact a lawyer, what should the clinic do? I guess it takes a while to get a court order. If the embryos expire before the court order, but the patients have proof that she's contacted a lawyer about this, can the clinic keep the embryos after they've expired?
Yes, and the HFEA have published guidance on this for clinics, which confirms that if there is a genuine intention to pursue legal proceedings, then clinics shouldn't dispose of material until those proceedings have been resolved. I say genuine only because there have been circumstances where patients have indicated that they're going to speak to a solicitor and then nothing has happened and time passes, and there isn't a clear answer to this, but there does come a point where the clinics can't wait indefinitely. I think the important thing is to notify the HFEA of the steps that they're taking and the reasons why, and then keep an eye on it and to take advice about it. But yes, if patients are proactive and genuine in their intention to seek legal redress, then it would be appropriate to wait for the outcome of that.
So a question now for Robert. This is another anonymous one. So from what you say, there's unlikely to be a way that a wife, same sex, can stop her estranged partner, divorce proceedings pending, from using her embryos in the future with a new partner, despite her being intrinsic in the treatment, signing the relevant forms and seeing it as their fertility treatment. They have 3 children, so any future children would be full siblings, but have different parents.
I am unclear and unsure around some of the stuff, I have to say. This is why I'm raising it, but I think potentially I am seeing that, yes.
Do you know if all patients with gametes and embryos in storage need to be offered the opportunity to complete the new WT-MT as a result of the Jennings case?
Not to my knowledge, no. Although I think the change in the storage rules means that clinics will be getting back in touch with people who do have material in storage. But I'm not aware of any suggestion that patients should be renewing their WT and MT forms. As we've said several times now, the new forms don't change the principles; they just change the sort of administration. So the forms as they stand are perfectly valid.
Okay, so the next question is from Smitra Bhatta. What are the implications of a mismatch in the couple's consent to use of the embryos posthumously? So this is something obviously that could come up if they don't sign the forms together. You know, if they're not doing the forms together and they don't discuss it, they're just in a rush, I suppose, or they just have a fundamental disagreement. So we'll go to you, James, for that one first.
Well, I'm assuming that the underlying implication of the question is if that this is only discovered in the event of somebody dying. I mean, obviously, if it's picked up by a clinic at the time of the completion of the forms, then that needs to be raised with the couple so that the differences can be resolved. If it's posthumous, though, that is really difficult because, again, the court nobody can look behind what's on the form. And so if the partner who had consented to posthumous use wished to use something which their partner had not consented to, then I don't see how that could go ahead without a declaration from the court. And I can't see the court giving that unless there was weighty evidence to suggest that the indication was somehow invalid.
I can see Robert nodding. Is there anything that you wanted to add to that, Robert?
Only to say, I suppose, that you would like to think that sort of situation is very unlikely to arise. And I mean, the most plausible scenario in which you might get to that point to find out that there's a mismatch, I would have thought, would be where it was being suggested by the remaining party that there was a mistake, that someone had completed, the other person had completed the form incorrectly, and that wasn't actually their intention. I don't know, again, it's not really within my compass. I don't know if you think there's any scope in that circumstances for taking something to court, James, to suggest that this form doesn't actually reflect there's an error on the form.
Well, yes. I mean, the courts will look at that, but again, it would be really difficult if they're dead.
If written consent has not been recorded, I imagine it's harder to find the evidence to infer consent. I suppose one of the cases you referred to, James, you know, they'd actually put a clause in his will, I suppose. And so what do you think about that? I mean, Diane Blood's case, she sort of seemed to remember that drew on, you know, she'd been looking at some magazine and then she'd been reading and she was sort of discussed it with her husband, and that was sort of quite a big plank of that inference.
Yeah, well, as we touched on earlier, the forms have been changed in an effort to make them clearer and to highlight the importance of considering these issues. Whether they've gone far enough, whether they've actually whether, as somebody said, it was overkill, I think will remain to be seen. I think I do sound a bit like a broken record. I think the real emphasis is on the importance of communication for the clinics when talking to patients about these forms, rather than relying on the patients to read the forms carefully and think about it themselves. I think we really need to draw their attention to the difficult scenarios that can follow. So I certainly hope that the forms are an improvement, but there's still obviously potential for patients not to read them properly or think about them.
Yes, who likes to read forms? Not many people, I don't think, like to read forms carefully, particularly when they faced with an awful lot of them in fertility treatment. So I think probably the final question for this evening I'll give to Claire McGovern. So she says, in respect of parents' posthumous use of gametes, do you think that the interests of the surviving parents in posthumous grandparenthood would be viewed differently in circumstances where there is no surviving partner, and therefore there's no conflict with interests with the surviving partner. So I suppose this could be a scenario where, unfortunately, both of the couple have been killed in a car accident or something like that, and so there's nobody there, but these embryos are in storage with consent.
I would imagine it's one of these situations where ultimately it's going to be the entire picture that's going to influence the view that a court takes. And each part of that picture will be part of its reasoning, but it's difficult to pick out one and say, well, that's the thing that will make the difference. It's going to be looking at the circumstances as a whole, I would have thought.